My name is Mike Dudman. I'm the director here in charge, if you like, of the New South Wales practice of Blackstone Legal Costing. Our business would have to be the largest legal costing specialist firm in the country, and we have offices in Sydney, Melbourne, Brisbane and even Maroochydore. And it's not just a plug for the firm, it's actually some interesting context as to what we're going to be talking about today, which is all about the different jurisdictions of legal costs throughout Australia. Recently, Blackstone published an interesting blog on this topic, and we got so much feedback, we thought, well, perhaps we should get in front of the cameras at Benchmark and give the viewers an indication of our views about the differences between the costing jurisdictions throughout the country. So to join the discussion today on the various differences throughout New South Wales, Victoria and Queensland, we're joined by an associate solicitor from our Sydney office, Dipal Prasad. Dipal, welcome to Benchmark, and it's great to have you. Perhaps you could just start by telling us what we're going to be looking at today.
Sure. The way legal costs are calculated, the process of cost assessment, and the powers of cost assessors are vastly different across various jurisdictions in Australia. Today we will be focusing on the New South Wales, Victorian and the Queensland jurisdictions, and we will have a specific focus on the advantages and disadvantages of each of the systems.
Fantastic. Perhaps if we start first of all by looking at the different ways in which costs are calculated in each of the states, both on the inter partes party-party basis and on the practitioner-client or solicitor-client basis. So how are costs calculated in the different states?
Sure. So in New South Wales, both party-party and solicitor-client costs are calculated on a fair and reasonable basis. This usually means that costs are calculated based on the cost agreement between a law firm and its client. Usually in New South Wales, the way costs are calculated are based on hourly rates or on a time basis. However, if the cost agreement is set aside or the hourly rate in that agreement is deemed unreasonable, then fair and reasonable rates will apply. The test for assessing costs on an audit or a party-party basis is set out in Section 76 of the Legal Profession Uniform Law Application Act, whereby the cost assessor must determine what a fair and reasonable amount of cost is for the work concerned. The test for assessing solicitor-client costs is set out in Section 199 of the Legal Profession Uniform Law, whereby the cost assessor must consider the validity of the cost agreement and the fairness and reasonableness of the costs. Section 172 further specifies that costs are to be both proportionately and reasonably incurred and proportionate and reasonable in amount.
If I can just jump in there, I think that's a really interesting new addition, if you like, to the regime for considering costs in relation to the question of proportionality. Previously, under the Legal Profession Act in New South Wales, proportionality really didn't form part of that act, but was certainly relevant under the Civil Procedure Act. Isn't that right?
Yes, the Legal Profession Act didn't have any specific provisions that costs had to be proportionate. However, the Civil Procedure Act did have provisions in relation to that. And there was also case law which required costs to be incurred in a just and reasonable manner. So that sort of alluded to the fact that costs needed to be proportionate and reasonable in amount, and now it's set out in the new legislation.
Yes, indeed, under the Victorian regime, isn't it? Previously, under the Legal Profession Act there, they did have the proportionality test as a component of determining fair and reasonable costs. And so many of the provisions really we've now adopted in New South Wales under this uniform law.
That's correct. But in Victoria, the method of calculation of costs is vastly different from how costs are calculated in New South Wales. Party-party costs in Victoria are calculated by reference to the relevant scale of costs prescribed by the court. Each of the applicable scales can be found on the Law Institute of Victoria website, each court has a different scale of costs, and the amounts noted on the scale often vary by year. Solicitor client costs in Victoria are usually claimed pursuant to the cost agreement a solicitor has with its client. The most common methods of charging legal work include hourly rate, as in New South Wales, or some cost agreements even just set out the scale or sort of adopt the scale to suit their needs.
Well, that's quite interesting in relation to the Victorian calculation of costs. In fact, it takes me back to almost the time when I started in this profession back in 2000, when the New South Wales system really had only fairly recently become deregulated, and prior to that, similar arrangements and scales were applicable in the district and supreme and local courts in New South Wales, of course. But turning now to Queensland, perhaps just tell us a little bit about the costs, how they're calculated there.
In Queensland, party costs are referred to as standard costs, and they're dealt with in Chapter 17A of the Uniform Civil Procedure Rules. Chapter 17A sets out the applicable scale of costs for the Supreme Court, District Court and Magistrate Court. The test for assessing costs on a standard basis is set out in Section 702 of the rules. And it says that when assessing costs on a standard basis, a cost assessor must allow all costs necessary or proper for the attainment of justice or for enforcing or defending the rights of a party. It's important to note that the test for assessing costs is necessary and proper rather than the fair and reasonable test which is applied in New South Wales.
And look, that was the test when I began this again in all those years ago. Necessary and proper, was even seen throughout the federal court scales as an example, and it was a very well known and actually more stringent test, if you like, compared to fair and reasonable.
Sure, it was definitely a more stringent test, but if we look at solicitor client costs in Queensland, they are calculated based on a cost agreement, and that cost agreement can also provide hourly rates. The relevant provision can be found in Part 3.4 of the Legal Profession Act in Queensland. And if there is no cost agreement, then the relevant scale of costs will apply. And importantly, what I was getting to is the test for calculating solicitor client costs is the fair and reasonable test in Queensland. So
the fair and reasonable test, and in many ways, even the new federal court scale, or the relatively new federal court scale, adopts similar methodology, necessary and proper, perhaps being left behind a little bit. So it's quite interesting, isn't it? There are different, if you like, nuances between each of the three states we're looking at today as to how those costs might be calculated. Let's turn now to the pros and cons, or advantages and disadvantages of each of those systems, if you like.
In New South Wales, I believe the positives are that time costing allows hourly rates, which allows practitioners to charge depending on their experience and skill. The fair and reasonable test is applied, which is less stringent than the necessary and proper test. This also means that it's easier to convert a party bill of cost to a solicitor client bill of cost, or vice versa. And the gap between cost recoverable on a party basis and a solicitor client basis is generally not as wide as it is in other jurisdictions.
Interesting. And I suppose typically we would start with certainly the solicitor client fees. There's cost indemnity principle to be considered. One can't make a profit from litigation, as an example. And therefore, the solicitor client fees really determine the most that one can recover on a party basis. And you're saying that the gap in New South Wales, in your experience, perhaps is less than in other jurisdictions.
Oh, definitely. We would come to it at a later stage, but in Queensland, the gap can be as much as 60% sometimes. Goodness. Because the scale is a bit outdated. I get it hasn't been updated in that jurisdiction for a long time, and you also don't have the high hourly rates within the scales.
So look, we'll have a close look at certainly the Queensland regime, but Just to finish off on New South Wales, there's obviously some disadvantages, isn't there, in relation to how the costs are calculated here compared to, say, other states?
The disadvantages are that it can be difficult to estimate the other party's costs because different hourly rates often apply. This is not the case when a uniform scale of costs is used in other jurisdictions. Being able to recover full costs means always accurately and promptly recording all time, either during or soon after the attendance. And the other disadvantage is that no uplift is allowed except in solicitor-client disputes where the cost agreement specifically permits an uplift, which is also quite difficult in New South Wales anyway.
Effectively a success fee.
Yes.
Yeah, look, it really is a little bit of a crystal ball task sometimes when we speak to a client who has a certain amount of solicitor-client fees on WIP, and they ask us what's recoverable on the party-party basis, largely really because it is difficult to know how a cost assessor might approach that task of determining what's fair and reasonable on the party-party basis, whereas the solicitor-client fees are generally recoverable pursuant to an agreement.
That's correct. If we move on to the Victorian system, the Victorian cost system has many advantages. One is that reliance on a scale of cost provides a uniform approach to claiming costs, which I guess makes estimating easier. Rates allowed under a scale are deemed to be reasonable, which provides certainty. Scale rates are periodically reviewed and indexed, so they keep pace with inflation. And it is arguable that time billing protects and facilitates inefficient or incompetent practices, whereas a scale of costs allocates a set cost to each discrete item of work.
Perhaps you can give us an example to those people, particularly in New South Wales, who perhaps aren't that familiar with scale items.
Sure. For example, a scale item might provide that an email up to 100 words are $37. If this was done in New South Wales, maybe that same email could have taken 0.2 hours to draft and at an hourly rate of, say, $500 per hour.
Might equate to a $100 fee for drafting that one particular email, depending on the circumstances and information, as opposed to simply the length of the email. Interesting. And perhaps we can turn now to some of the disadvantages of the Victorian calculation of costs.
So the scale provides just one rate for all legal practitioners and does not take into account the solicitor's experience or expertise. The rigidity of this scale does not allow a practice to use a wide range of fee earners with various levels of experience in the same way that a cost agreement would. For example, the Supreme Court scale has just 3 basic rates, the highest rate being $402 for a solicitor, which is regardless of experience, plus a loading of up to 15% for
care and conduct.
Yes. And the lowest being $232 for a clerical attendance, again plus loading, which I guess that can also be construed as an advantage.
There's certainty around the number, isn't it?
Yes.
Whereas in New South Wales, isn't it true to say we see cost agreements sometimes with 8 different types of fee earners, ranging from senior partner through general counsel all the way through to paralegal, secretarial, administrative assistant rates, don't we?
Sure, we do, and sometimes the hourly rates are reduced on assessment, which reduces the total amount of the bill of costs.
Of course, and also increases the unpredictability of the outcome. Can you think of any other disadvantages in relation to the Victorian calculation of costs?
Yes, actually, when a cost agreement is based on higher hourly rates, as might be the case for, say, a specialist lawyer with city offices, the gap between solicitor-client costs and party costs can be significant. So that's just one other disadvantage.
Okay. Well, that was quite an exhaustive analysis of both New South Wales and Victoria. What about Queensland?
Queensland, similar to Victoria, allows a care and consideration uplift in percentage, which covers some attendances not recoverable pursuant to the prescribed scale of costs. The highest uplift that can be claimed in Queensland is 30%, which is reserved for the most complex cases. But if we focus on negatives, the relevant scale of costs has not been updated since 2013 and is well out of date.
Well, that's a really interesting point, because the Victorian scale, does that not get updated more regularly?
It gets updated every year.
There you go. Whereas the Queensland scale, it's 5 years old.
It definitely is, which leads to, I guess, the 40 to 60% gap between party and solicitor client. The big disadvantage is that the necessary and proper test is applied for party matters, and the fair and reasonable test is applied for solicitor client matters. So again, there's that leads to a big gap. But it also means that limited costs are recoverable in party matters.
That's a really informative discussion around the calculation of the costs. But let's turn now to the processes and how each of the states differs in that respect, and what steps parties can take to recover costs.
So the cost assessment process in New South Wales is paper-based. In short, a bill of cost is prepared and served on the cost respondent. In a party cost dispute, the cost respondent has 21 days to file a notice of objection, and in a solicitor-client dispute, the cost respondent has 30 days to file a notice of objection. The cost applicant can then prepare a submissions in response and file an application for assessment, enclosing a bill of cost, a notice of objection, and the submissions in response. If an application for assessment is filed without the supporting documents, then the cost assessor can require those additional documents, and then we'll fix a timetable for provision of those documents. Clients in solicitor-client disputes must file an application of assessment within 12 months of a bill being provided to them. Solicitors, however, in solicitor-client disputes can only commence proceedings to recover costs claimed in a bill of costs 30 days after service of that document on a client, subject to provisions set out in Section 194 of the Legal Profession Uniform Law.
Interesting. So when it comes to the process of assessment itself, clearly it's paper-driven. In your experience, do cost assessors tend to call for a file to see the substance or the work actually performed behind an application for costs?
Yes, the cost assessors have that power. The regulations give cost assessors the power to require a file if enough information is not provided within the bill of costs. And we have seen this happen several times. If they don't want the entire file, they might require certain portions of the file. For example, just copies of all the disbursement invoices, for example.
Of course, they'll always ask for the costs agreement.
Yes.
My experience has been that probably 90% of solicitor-client disputes involve the file being called for to substantiate the costs as itemised within the bill. Not so much in party disputes, though. Is that what you found?
I have experienced the same thing. I guess not so much in party because it is expected that the bill of cost does have sufficient detail to justify why, I guess, certain time has been spent on that task.
Yes. And the other thing, I suppose, about the assessment process in New South Wales is cost assessors do go to some very lengthy lengths, if you like, to ensure that all parties have a procedural fairness and an opportunity to make submissions or responses, provided it's done in a timely fashion. Sometimes we see invitations for preparation of a reply to a response, don't we?
Yes, we have seen that, which just makes the paper-driven process lengthier, and can also mean that a certificate of determination, which is the final document certifying how much costs are payable in a matter, that sometimes isn't provided until 6 to 12 months sometimes.
Indeed, it can be quite a lengthy process, whereas in some of the other states, I mean, let's turn to Victoria. I think they have a fantastic system down there now, in my experience, in terms of getting through cost disputes. Perhaps you could take us through that.
Yes, so in Victoria there is a cost court that hears and determines all cost matters that arise from the state's courts and tribunals. It also hears cost disputes between legal advisors and their clients. Cost proceedings are commenced by way of filing a summons for taxation and the bill of costs. If in a party-party taxation, you will also need to include an information form and the cost order, being the judgment or a deed of release, and the filing fee. A filing fee is not required for solicitor-client disputes. Similar to New South Wales, clients in solicitor-client disputes must file an application for assessment of costs within 12 months of the bill being provided to them. But solicitors in solicitor-client disputes can only commence proceedings to recover costs claimed in a bill of costs, not until 30 days.
So in Victoria, what happens once the bill has been served on the other side? What's the process around that?
Well, all party-party bills of costs that claim costs under $50,000, including disbursements, are sent directly to assessment.
And what about costs above $50,000? What's the process there?
That bill is then listed for mediation.
I see. And if it fails to mediate, then it's sent to assessment.
It's listed for taxation if it fails at mediation.
Anything more to say about Victoria? Perhaps we should move on to Queensland. I mean, that itself is an interesting process.
We could move on to Queensland. Queensland does not have a cost court. Cost proceedings in Queensland, similar to New South Wales, are paper-based. To claim costs on a standard basis, the cost applicant needs to prepare a cost statement based on the relevant scale of costs.
Okay. Now, in terms of cost assessors themselves, it's an interesting market-driven model in some ways, isn't it? Because there's a list of cost assessors who are available to parties to have appointed by agreement, compared to, say, New South Wales, where there's a list of 54 odd cost assessors appointed by the court. They are appointed by the court in Queensland, but it's down to the parties to choose who would be appropriate.
Exactly, that's a very important distinction that Queensland has in comparison to other states. The parties have the option of choosing a cost assessor by agreement from a panel of about 45 court-approved cost assessors.
Are they all charging the same amount or hourly rate?
No, they're not. So they have their own hourly rate set out within that list of court-approved cost assessors. Once the chosen cost assessor provides consent, and once a consent order with respect to the assessor to be appointed is filed, the registrar can make appropriate orders and vacate the usual directions hearing date. If the parties cannot agree on a cost assessor, the judge or magistrate appoints a assessor at a directions hearing. There's actually case law to say that when the parties do not agree to a cost assessor, then the cheapest one can be appointed.
I see, and the court will actually step in to make that appointment.
Yes, and then the court-appointed assessor just undertakes assessment and provides a certificate of determination.